Utica Corporation Counsel on the Chief Brooks situation. We have not heard the city's side. We've certainly been able to hear the chief's side. And, gentlemen, good morning.
Good morning. Good morning.
Somehow I got to get you guys on really tight on a microphone.
There we go. Sure.
That's a little bit better. Okay. So what did we learn out of the – first of all, I guess, as you've heard, we've certainly talked about this a lot on the radio, and we've had Chief Brooks in several times. I'll just ask, how can you justify the way Chief Brooks has been treated by the city? And because and speaking to the mayor, he feels it's justified. How do you guys justify it?
Well, our position with the Corporation Counsel's office is Chief Brooks was treated just as every other employee of the city of Utica was. Bill, I think it's important to note that, the Corporation Counsel's office has done probably, 80 to 100 of these 207A and 207C cases. When we talk about 207A, that's actually the workers' comp for firemen.
Yeah,
so when we say the word 207A, that's what we're talking about. He was treated no differently than anyone else as far as city is concerned. We treat people, of course, with respect. We review the applications. We have the medical doctors look at the situations, and we make a determination from there. I think it's the fact that Chief Brooks brought this down to a more personal level.
Yeah.
I mean, I don't know, but I've never heard of, in all the years I've worked there for about 24 years now, of anyone, within a few hours of being placed on leave going right immediately to the press, to the media. And I think that was a bit disconcerting for us because we look at confidentiality, we look at respect.
And you believe that he misportrayed, he did not portray properly what happened in that meeting?
Absolutely, all day long. We had a transcript done, and he knew we had a transcript
tape recorded.
Yeah.
Tape recorded.
And it could be released if he would consent.
I did bring that up, although I do believe that Chief Brooks might have reassessed how that went down. And what he told us was they were very respectful. How did he word it? Do you remember? But it was more of you had to read between the lines. So I think that he's changed that story. But I do recall in the beginning, it did seem that you guys, I don't want to use the word bully, but you really bullied him.
Yeah, like you threw him out, threw a quarter at him, and said, "Take the bus home," something like that. That was kind of the
and you're
version
saying
we got.
that didn't happen that way.
Absolutely not. And one of the reasons that we actually taped it, and he was aware of it, and we immediately sent the tape, we transcribed it, immediately sent it to his attorney, Jim Romer, was for this reason.
Yeah.
Because we knew at some point, possibly, that we would be here doing one of these
right.
segments right now. But absolutely not. I mean, we would never, the city of Utica, that's not what it's about. I mean, it's a very professional office. Again, we've done 80 to 100 of these. That's not how we would treat people, particularly someone like Chief Brooks. He was a bureau chief. He continues to be a bureau chief, although on leave right now. And nothing could be further from the truth. And that's why I know that you've indicated he wants to reassess it, but why did it go out as it did back then? I mean, we have editorials that I brought with me from people that said we didn't give him a ride home, that we did all these things. Absolutely untrue.
The thing to bear in mind, Bill, when you're dealing with these workers' compensation cases is we have to be guided by medical opinion. Okay, I don't have a medical degree, neither does Bill, neither does anyone here. But what happened
I think I do.
Oh,
I act like I do.
And you do.
So do other people we know, and we run into trouble with that. But what happened in this case was Chief Brooks, he brings this application for workers' compensation. We do what we would ordinarily do. We gather up all the medical recs, and then we have them reviewed by our doctor. This was done in the April-May time frame last year, and our medical opinion came back and said, look, this individual has some very serious health problems that make it dangerous for him to, say, take command at a fire scene. It could be serious. I mean, we're talking things like heart condition, diabetes, things that are serious. And it's in his best interest that he be put out on medical leave. And we were guided by that opinion, as we are in all cases.
I find interesting, there was also a note from the doctor in there that he maybe was putting, it was the doctor's opinion that he could put his firefighters in the community at risk, and I think that creates a major liability for the city.
Well, absolutely.
Right?
If we're being told, I mean, we were being told by our doctor that, given his conditions, if something went wrong at a fire scene, anything could go wrong from, a heart incident to sudden death. Well, if something like that happened and something went wrong, well, then whose fault is it? We knew. We were advised. We were on notice.
Now, he says he has a doctor that says something completely different.
Yeah, that's true, and that's the interesting thing about this case is when we put him out, or when he was put out on the medical leave back in May, he did for several months thereafter, right up until August of 2017, he produced medical reports from his various treating physicians, all indicating that, as far as they're concerned, notwithstanding his coronary, his diabetic, and his other health conditions, he's fine to do the job as fire chief. Now, of course, this contradicted what our doctor was telling us, but he was actively maintaining the position that, you know, I'm fully capable of doing the job as fire chief. You shouldn't have put me out on leave. That all changed in September when that new law was signed. And then all of a sudden, well, now I'm disabled, put me on sick time.
Can I ask you, and this is what the court fight, and we had the chief on last week, this is what the fight is about.
By the way, we have in studio Bill Borrill and Armond Festine, Utica Corporation Counsel. It's the first time we've had the city's side of the story.
That's right.
Here.
I want the city's opinion. We asked Chief Brooks this from the very beginning. It doesn't make sense to me. Although he's explained it that he wants acknowledgement. He wants recognition.
And his attorney confirmed that.
That's what his attorney said. Is there anything for the chief to gain by the two claims he filed, the 207 or this 92D? He says he's not looking for money, he's not looking for time off, not looking for a bonus, not looking for anything. Is there anything to gain by this?
As far as Chief Brooks financially?
Correct. He claims the World Trade Center Health Organization covers his medical bills. He's not...
Well, he claims that the only gain in this is with the city accepting, because it seems like we're dealing with two different things here. In the beginning, it was he should be able to do his job. Now it's acknowledgement, and that seemed to be what the court hearing was over a week and a half ago. So the question would be, he says the only gain is going to be the city will be reimbursed for any of the sick days.
But that's not necessarily true, and that's one of the issues that we've had.
Right.
And the issue is under the 207A, because, Jeff, you're right, there's two different situations here, 207A and 92D. All right, he first started out with the 207A, and, you know, we've heard from Chief Brooks as well as his attorney, Jim Romer, that basically the city will be reimbursed if we just let him go under 207A. But that's not the question. The issue is the causation. Did he get CLL leukemia when he was at 9/11? And all of the doctors that we have used, Dr. Holland, Dr. Silverman, have said absolutely not.
But you have the World Health Organization, this World Trade Center Health Organization.
And let me comment on that, because there's two very different legal bases to what's going on here. The World Trade Center Health Organization is something that was created by federal law in 2007. It's also been called the Zadroga Act. You might have heard that term used. What that does is it creates an agency under the auspices of the National Institute of Occupational Safety and Health and Safety. And what it does, it really does three things. It does monitoring, it does research, and it does provision of direct medical care. And basically, it has established a list of conditions. And to the best of my knowledge, those conditions, they fall really into three categories. They fall into respiratory diseases, they fall into digestive diseases, and cancer. And one is eligible for the benefits under that federal law if, in fact, they were at the World Trade Center site for designated amounts of time, and they have been diagnosed with any of these conditions, then they will receive the benefits of that statute as a safety net without the necessity of having to prove causation or a local workers' compensation case, which means basically causation. Now, that said, under New York law, there is something known as a qualifying World Trade Center condition. That is a different legal creature. It's something that exists under New York law. It's defined in the New York Retirement and Social Security law. And basically, in order to have the qualifying World Trade Center condition, it has the same general category of medical conditions, such as respiratory, gastroesophageal, and later onset diseases like cancer and so on. But one must also prove a causal relationship between the actual exposure and the onset of the disease later on. Now, in the case of Chief Brooks, it's a very well-documented fact, based upon the book that was written and the accounts of the various other firefighters that went down there, that there was only approximately 7 or 8 hours of actual time spent working in
but we've seen recent reports that say if you were there and you breathed the air in for just a mere couple of minutes, that do you remember that story coming? That was part of what the governor put together for first responders.
Well, the toxicologist, Dr. Holland, that we use, who's very well known. I mean, his curriculum vitae is pages long.
And he says that's not true.
Not true.
Not true.
And that's very, and having learned a bit about toxicology from being involved in this case, everything is toxic or not based upon dose.
Okay.
And that's important.
I want to, I would say we're getting into the weeds, but that's where you guys play, is in the weeds. That's your job.
That's what we do.
I have a few questions. First of all, though, I want to say, could this have been handled differently? And I only say this by, why couldn't the chief have been given strict orders that this is administration only. As long as you have this condition, you can remain as chief, but we cannot have you going out to fires. We can't have you running into a burning building. We can't have you.
Well, you don't know Chief Brooks very well, do you, Bill? You think you could tell him not to do that if he's there as chief?
I'm just
No,
saying.
I mean,
I'm just saying.
Do you think for 1 minute that if he was there, he would not take command?
Well, the issue that we have, all kidding aside, though, is the issue that when Chief Brooks opened up this Pandora's box, which is basically what he did. I mean, he's the one who presented us with this information. We didn't go to him, okay? When he opened this up to us and gave us his medicals, and our doctor looked at it, Dr. Silverman, first of all, said, look, first of all, he didn't get CLL from 9/11. And second of all, based on these medicals, all these other reasons, he shouldn't be the fire chief.
So with that said,
but are there other restrictions as far as civil service? You can't mandate what the fire chief's job duties are. Oh,
certainly.
Civil service does.
Okay.
Well, civil service, we also have the job description, too. One of the job descriptions is he would take command at fire scenes. I mean, it's we have it here with us.
It doesn't help, though, that we know, it's well known, that Chief Brooks and the mayor do not like each other. I mean, I'm only saying because remember, the person who's been able to drive that argument has been the chief. You guys were not able to talk, and that puts you in a very difficult position. But you have a hero. Call him what you want. The guy has come off to people in this area as a hero. There are pictures of him coming out with a baby in his arms and a fire, and in terms of public relations. Wow, this is a toughie.
Well, the question, and this is one of the concerns that we had when we first got this application for 207A, and then we eventually put him on the Section 72 indeterminate leave, is the issue that we have with Chief Brooks is we're not taking away from his many heroic things that he did as a fireman, okay? He did a great job, okay? With utmost respect with him for doing those things. But the issue that we have is that, and this is where you said that we play in the weeds, this is exactly it. Legally, the doctor said he can't work there anymore. So whether it was firefighter Russell Brooks or firefighter Bill Borrill, the doctor said he can't be there. And we did exactly, we followed our protocol, and that's
what leads me to this question. One of the things that has been thrown around is that the mayor did this, and you two came in and had to clean up the mess.
Absolutely not.
So give us that timeline, because that has been something that has been tossed around a lot.
That is absolutely not correct. We were involved, and not just Bill and myself, but we work as an office.
Did you both advise the mayor that this has to be done?
Well, there was a not a committee, but it was myself, Armond, the mayor weighed in on this. We have a risk management firm also that we use that we've hired. We have Annie Lalonde, who is a specialist, labor specialist. I mean, we made sure we dotted our I's and crossed our T's on every case, but particularly this one because of the bad optics on it.
And all of the information.
The bad optics, which is
all of the information that came in, the medical information as it surfaced and as we gathered it up. This was all shared with the mayor at all times, and this was not, to say that this was something that the mayor did on his own and we're here to clean it up is just completely inaccurate.
I don't mean, I hope I'm not coming off disrespectful by asking the question, but it's something that's been tossed around.
Not accurate.
Not accurate at all. And, the mayor, we advise the mayor. We represent the city of Utica in our office, okay? We advise the mayor. And, we hope he listens to us. He normally does. 9 times out of 10, the mayor listens to our direction. Okay.
Did he listen to you here?
Absolutely.
All right.
Absolutely. Yes. Based on what the doctors reported, absolutely.
I did. I will be, in fairness to the mayor, I've had several conversations with the mayor. Some have gone on quite a while, and some he's kind of cornered me. He's cornered me, and I couldn't get away. But I will say this: that he said the easy thing for me to do would have been to let this go because I knew I can't win this in the eyes of public opinion. Absolutely. This is going to be ugly for me. The right thing for me to do would be to protect the city. Now, that's what you're saying the case is.
All day long, because these 207A cases, if he had just acquiesced and said, look, never mind what the doctors say. All right, first of all, that's wrong. Yeah. Okay, that's not what we do. Okay. Second of all, if we had done that, then we would have had done it for the next firefighter or the next policeman that came in and said, look, you gave it to Russ Brooks, you should give it to me. But you weren't injured on the job. Okay. So this was bad optics for the mayor from day one, but he did the right thing. 100% he did the right thing.
Do you feel that if the public heard the tape, not just read the transcript, but actually heard the audio tape, do you feel that would change the public's opinion?
Perhaps. It was really a very brief meeting, and it was very respectfully conducted.
Would you call the meeting somewhat clinical, legal?
Well, it was, yes, we read him the rights. We told him that we were taping it. We told him not to really discuss it with us because he had an attorney at the time. We read him all the prerequisites about what we were doing, how we were going forth. We read him, we
provided him with copies of all the medical reports that we had, that the decision was based on, and we simultaneously scanned and emailed everything to his attorney. So there was some contemporaneousness there in terms of his counsel.
All right.
And one of the issues that we also had was the fact that people were indicating that we didn't give him a ride home or anything like that. Completely untrue. We had someone there ready to bring him home. We said you can leave the car here. We can have someone take you home. He chose to take the car back to the station.
You had to expect that he would have seen this as something that was disrespectful. Right. Did you anticipate that?
Yes, I
kind of figured it was going to end that way,
and that's why we dotted our I's and crossed our T's and did what we did.
Can I ask you quick? You guys are going to hate this. You got 10 seconds. The case right now is his lawyers claim $165,000 approximately could be recouped by the city for accepting this 92D. Why do you say that's not the case?
Because you can't recoup the money from the state if he's not entitled to the benefit in the first place.
All right.
Okay.
To be continued. Gentlemen, I'm glad we had a chance to talk with you.
Thank you very much.
And we really are trying to be fair. I know
we appreciate that.
Might not come off that way, but thanks so much.